discussion session in Hall B on the topic of ethical considerations in intellectual property practice, exploring ethical issues and best practices for IP attorney and professionals. To discuss this, I would like to welcome on stage the moderator of the panel discussion, Mr. Saurabh Anand, who's a senior counsel, IP and technology law, Akamai Technologies. Our second panelist, Mr. John Cabeca, from United States Intellectual Property Council for South Asia, American Embassy. Our third panelist, attorney, Ms. Vasundhra Prasad, at the Supreme Court of India and the Delhi High Court, New Delhi.
Good morning, everyone. Thank you all for joining, and thank you for the organizers for having this wonderful session on ethical consideration and intellectual properties. So without any further delay, I would like my panelists, John and Vasundhra, to just give a brief introduction for themselves so that we know who we are and so that we can engage in a fruitful conversation going forward. John, if you can just introduce.
Thanks, Saurabh. Good morning, everyone. Is this one?
Yeah, can you?
So I'm John Cabeca. I'm the U.S. Intellectual Property Counselor for South Asia, based out of the U.S. Embassy here in New Delhi, but serving all of the countries throughout South Asia. I thought I would just very briefly give a quick overview of what that means. So I'm actually fully supported, and I get all my strategic direction from the U.S. Patent and Trademark Office. There's about 13 posts around the world where we have these IP positions. And essentially, there's three primary focuses to the work that we do. One is government-to-government work on advancing IP policies, IP ecosystems, collaborating, sharing best practices, and doing what we can to help support a stronger and more vibrant innovation ecosystem throughout the region. The second pillar is one where we work with industry, primarily looking to enter the Indian market, trying to get an understanding of the differences between our respective jurisdictions, how our courts work, and so on, and also advocating on their behalf when we see issues that might be impacting their ability to obtain and secure IP protections and enforce those rights. And the last one is one of outreach and education and awareness, where we work very closely with the IP office here and throughout the region, and the offices throughout the region, to help promote IP awareness and education and the need to respect intellectual property. So thank you.
Thanks, John. Those three pillars will always give a brief what you do in your daily life. Vasundhra, if you can just introduce.
Hi, thank you, Saurabh. Thank you, John. I'm Vasundhra Prasad, as you can see from the brochure. I'm an attorney, I'm specialized in intellectual property law. I did my master's as a Dean Scholar from New York, worked with United Nations headquarters in New York for a specialized organization known as the World Intellectual Property Organization, and then got back to India, worked with Amarchand Mangaldas, which is one of the leading corporate houses, law firms, and then went into in-house because I wanted to experience the part where you're representing an organization by yourself. I worked with Goldman Sachs, the Fortune 500, then moved to Cisco Systems, a tech giant. Recently was a general counsel for a European major. At present, I'm a practicing counsel in the Supreme Court and Delhi High Court. My area of practice has been intellectual property law, but of course, being an intellectual property lawyer, you also have to look at other scenarios and other specific commercial issues, so you have to look at corporate law as well. But in terms of my practice area for past 23 years, it has been intellectual property law and internet law, cyber law. Thank you.
Thanks, Vasundhra. Okay, brief about myself. I work as a senior counsel at Akamai Technologies. My work primarily revolves around intellectual property laws and technology laws. By way of background, I'm a seasoned litigator. practicing primarily in IP litigation and highly specific in patents litigation. Was working with in Singh and Singh under Justice Pratibha Singh in my initial phase of career, then moved to KNS Partners, an Indian-based law firm, and in 2021, I made the switch and entered into the corporate region, also called in-house role. I primarily oversee Asia Pacific region and few US-based regions and work in that particular jurisdictions. So yeah, so we have a mixed panel from John, practicing attorney, and an in-house lawyer. And we'll try to make the session a fruitful one by giving a practical advice rather than making it too legally, so that we can gather some feedback and gather more experience. I'll probably start with you, John. What's the US perspective on ethical considerations for any IP practitioner or professional?
Thanks, Saurabh. And I have to, so I've been at the US Patent and Trademark Office now for 35 years, and even before joining the USPTO, ethics has played a big role in my life. I used to work at the library on campus at the university, and I had to report my professor for stealing a book called Ethics and the Responsible Engineer, which I thought was very funny. But then coming to the USPTO, early in my career, I was helping on our call center, the helpline, the Patent Assistance Center, and I received a call from an inventor who was very excited to actually finally speak to somebody. And he says, oh, I just want to get status of my application. And after talking to him, I realized he had become a victim of an invention promotion firm that fraudulently took tens of thousands of dollars of his money, US dollars, and never filed an application on his behalf, and basically left him high and dry. And it wasn't, so he found the USPTO too late. And then back in the 90s, we had a lot of problems with that, and we actually developed and expanded our Office of Enrollment and Discipline within the US Patent and Trademark Office. And this office is responsible for administering the patent bar exam and also investigating the conduct of patent and trademark counsel throughout the country. Today, we have over 25 attorneys that do this full time, and they are very responsive to complaints that they receive regarding the conduct or misconduct of a practitioner, or it might even be something that is mentioned in a court decision. So you may remember back in September here in Delhi, the Delhi High Court issued an order asking the IP office to come up with a plan to regulate and manage the conduct of patent and trademark agents in the country. And so in the USPTO, if we saw an order like that, then this Office of Enrollment and Discipline would immediately pick it up and start an investigation to figure out what steps need to be taken. And at the end of these, so generally, I think I'll just quickly cover some of the types of issues that we see. Primarily, we see neglect or abandonment, like as in the case with the Delhi High Court decision where the applicant's representative basically stopped responding to the applicant and the case went abandoned. Failure to communicate, lying to the client, lack of candor to the USPTO, and we've seen a huge surge in USPTO sanctions on trademark counsel because in 2019 we had we had a domicile requirement that any trademark applicant from around the world needs to file their application through US counsel. So that has created a lot of things I think we'll talk about a little later. And then also, as I mentioned, the invention promotion firms. So it seems after we conduct our investigation on these and other matters, it ultimately boils down to what are the steps that the USPTO, what steps will our office take? And will they suspend their license? Will they require them to go to continued legal education on ethics for a period of 3 years? And so they set these different parameters. Sometimes they settle. And a lot of times, because the evidence is so strong, the attorney just turns in their license and withdraws their ability to practice before the USPTO. So it really just depends what the issue is. and every single one of these cases are made public. And again, we'll talk a little bit more about some of them in a little bit. But
Glad, John, you mentioned about 25 attorneys working with USPTO and primarily on the misconduct part. Have you, other than India, of course, have you also witnessed similar examples for other jurisdictions? Because you're exposed to other jurisdictions within the Asia Pacific region. Any specific example other than India, if you can just provide on similar thing happening anywhere else?
so I can't speak specifically of what the other offices do, but I believe that Japan and Europe have similar steps in place to monitor the conduct of their attorneys. And some of it falls at a higher level, like within, the USPTO is very specific to intellectual property, but within the American Bar Association or the respective countries' bar associations, there may be mechanisms with which to address it. Like, for example, in India, I think the Patent Act, Section 130, has something where they can, the office can withdraw the license of an agent, but there's no regulations currently in place to show how that would actually be implemented. But it's something that the head of the USPTO's Office of Enrollment and Discipline has come to India, and we've had a really great discussion with the IP office here to help inform, like, what are some of the things we did in our over the past several decades in developing our office and this oversight.
Thanks, John. And definitely there is a provision, but I believe has not been utilized so far. Like, in my experience, yes, it has been utilized once or twice, but not sure what was the fate of that particular decisions. Okay, great. And just one last question to you, John. Whether these 25 attorneys limits themselves to patents or trademark kind of complaint, or it's an overview of IP, like all forms of IP, which a USPTO will deal with?
So it really could fall to anything. For example, if the attorney is convicted of a crime and sentenced to prison, we will suspend their license for that term. And so a lot of the times the actions of the agent or attorney does impact their ability to practice before the USPTO, even though it might be totally unrelated to IP.
Understood. That's glad to know. So probably like we have a broader understanding how USPTO is working, taking steps, and ensuring it has been complied with in the best form manner, whatever is
It could
possible.
extend to, like, if they've declared bankruptcy or things like that. We look at, we respond to complaints and information that we receive.
Okay.
Regardless of its source. So.
Glad to know that, John. So, Vasundhra, you are a practitioner. Like, what do you think there is a specific differentiation for ethical consideration in India vis-a-vis IP practice or general practice, or we have to see both from the same lenses?
All right. Perfect. Thanks a lot, Saurabh. Thank you, John, for letting us know more about the USPTO and its functioning and the ethical protocol that we have to follow in the USPTO. Well, in India, I'll talk about intellectual property as a whole, and specifically to India. Let me first, let the audience know what intellectual property is all about. It's actually a negative right. It prohibits you or restricts you from using the creation of mind of somebody else. So it's a negative right on the face of it. So it definitely has a stronger threshold for ethics. The ethical threshold that you have to follow in intellectual property litigation is far higher than any other litigation for that matter. And that roots back to not only the code of conduct that a lawyer has to follow, being a part of the Bar Council of any other country, or any country for that matter in India, we do follow the Bar Council regulation and code of ethics, which talks about ethical responsibility of lawyers. But other than that, we have ethics ingrained in the intellectual property law as well. We have sections specifically to it, but we have in the practice, in the practice scenario, we have specific ethical codes that every lawyer representing an organization or representing a client has to follow in. And that's to safeguard not only the interest of the client, but also to safeguard or in terms of the precedent making that we have in this country, being a common law country. Most of the case laws that come out have a substantial value in terms of the law it brings forward. So in terms of ethical considerations, we'll talk about ethical consideration, but the threshold for intellectual properties ethical scenarios far higher than any other law for that.
Yeah, so can you just give some examples of with what kind of ethical consideration are peculiar from an IP perspective? Because considering that bar is higher for an IP professional as compared to general practitioner, a few examples will definitely help the audience.
All right. So, I'll go for the broader scenarios, and there are specific cases with regard to each and every specific law. So we have in patents, I think there's a very strict ethical consideration that we talk about, Section 8 and Section 64, which makes it discretionary on the part of the court. But other than that, we have copyright and copyright infringement and plagiarism. I think that's a very critical aspect to it. Software patents, or I'm not talking about software patents as such, but I'm talking about open source is an area of law which is highly it's a free world out there. So that's something that ethically as a lawyer you have to make sure that your client does not only use the open source but also does give the credit to it or does attribute the significant changes that he's made to the open source. Other than that, you have aspects of trademark infringement where you have extremely important ethical scenarios that you have to consider as a lawyer. And that also that's also in terms of dilution aspect to it, but also in terms of also in terms of just the trade dress aspect of it as well. Lastly, I'll talk about cyber squatting and cyber or the internet law. I think that's also a law where a lot of times ethical issues are not being considered, and we'll have cyber squatting on a very regular basis. So those are the scenarios that I'll talk about in terms of ethical issues that come up as a lawyer of intellectual property law.
So primarily just one last question from you, Vasundhra. You mentioned about cyber squatting, and these kind of issues are regulated in major jurisdictions. However, we are governed by precedents, by the various courts across. Do you think there a difference in your day-to-day activity by not having a backup legislation where you can fall back, or you have to always refer to precedents?
All right, we always have India, or for that matter, most of the common law countries are a part of various WIPO or the United Nations, the World Intellectual Property Organization's conventions. We are a part of the Paris Convention. We are part of the Madrid Protocol, which talks about trademarks. We also part of the PCT. We are also part of the PCT. So most of these conventions also help you in terms of managing the expectations or kind of harmonizing the law all across the jurisdiction, especially the common law countries. So even if you don't have a specific law in your country, but being a part of the conventions, be it the WPCT or the WCT, which is the copyright treaty, most of the common law countries are a part of a larger regime of intellectual property, and they can even the country-specific precedents are affected by these conventions.
Glad to know that. So at least we have some stopgap options to fall back till the regulations are coming. Glad to know that. Okay, so I will try and give up from an in-house perspective, because now there are a lot of differences what we as an in-house attorney faces, and one of the first and foremost issue what we, and I'm sure most of you can relate to, we don't know who our clients are. It could be the CEO, it could be the finance director, it could be the information security head, it could be marketing head from the trademarks perspective. And that's the major issue was for us to manage the risk for an organization. I'll give you a very recent example what we are working currently in. So we have a new solution to launch, and our CEO has given a heads up it has to be launched. Whether finance have stated, okay, this is a new and innovative, it can be considered as a new solution, but we don't have necessary funds for that. Then marketing has gone ahead after taking the CEO's approval and started the marketing. Even this whole concept, how to market, how to launch, has not been finalized. An information security team is coming, and there are a couple of issues to be handled in Japan, issues to be handled based upon China's regulations, issues to handle in Australian perspective, multiple issues altogether. And we are the receptive of all this information. From IP professional, if I limit myself primarily to filing a patent application, filing and securing a necessary trademark, it will not help. And we are across these conversations and we actually don't know to draw the lines, whether I am responsible for my organization per se or specific teams within an organization. And that's why when I came back from my litigation to in-house perspective, and that's one thing which we are still working on and we don't know what the answer lies. So that's one thing which is very important and which always comes across our table while working in-house on these kind of issues. Secondly, we have a strong interdependence relationship with our general code of conduct or business code of ethics. I'll give you an example. I kind of gave or say okay to file a patent application somewhere in US. And then we got sued before that. And then whole ethics committee will sit on us who gave the approval. And when the whole postmortem will start, who were the necessary stakeholders, who gave this approval. And that's why, and the expectation from these ethics committee is primarily from now changed from an IP perspective to a generalist perspective. And our responses become very crucial because other person's jobs are at stake. So our problem within an organization from an ethical consideration is not only limited to intellectual property, although it started with intellectual property, but it will end somewhere else. So we have to keep on managing the risk from various different organizations and working within the organization, different entities based on different jurisdictions, different teams across altogether. So that's why, like for me, it's purely black and white in terms of what different people are telling, and then bringing all together in one room. And this is your problem. This is your problem. This is your problem. Please talk and find a solution so that we can go as a. But as you all know, it never happens because you are in different jurisdiction, different time zones, different organization members involved. That's some of the issues what we come across. And one thing more I would like to touch upon is our communication with practitioners. Say, for example, I'll reach out to you, hey Vasundhra, like, what's your opinion about this? And you will give me an honest opinion. Saurabh, there is a risk. This is the managed risk position, and this is how you can proceed. Now, if it is going beyond 2 pages, no one within an organization will read. So Vasundhra has given me her experience, but it's my job to, kind of concentrate in like bullet points to communicate internally. Because that's one of the biggest problem, and if everything falls back, then if people will come and tell, okay, external counsel has advised us. But for me, it's become more important as the in-house perspective that whether I have carried forward those checks and balance provided by the practitioner within the organization in the correct fashion or not, whether I have highlighted the red flags, whether I have given the way outs in those 5 bullet points. And whole job boils down to creating those 5 bullet points and managing the risk. And second, again, like for example, if we as an in-house counsel found a loophole or find of a suggestion to be given to an external practitioner, then also there is a tendency within organization not to listen because they'll always fall back, okay, they are more experienced. They have exposure to multiple clients, they have exposure to different things. So let us fall back on their opinion, and it's most of the time in-house lawyers' opinions doesn't matter. It will only matter when things will fall apart. And again, we have to reach back to the practitioner, make it a collaborative approach, bring a business use case to the organization and manage not only business, but considerations and also ethical consideration involved because different teams are involved here. So that's a different ballgame altogether for us working in an in-house environment vis-a-vis an IP perspective. So that's a good discussion on like from John's perspective, Vasundhra's perspective, in-house perspective, and we'll probably pause for a minute or so to take questions before we go ahead with the next topic or discussion regarding best practices for IP professional. If we can take questions after the session as well. Yes, please.
Thank you. My name is Rahul. I practice IP law. I just wanted to ask, from your experiences, how do you handle conflict of interest when it is an issue conflict in one case as a practitioner, you advising a claimant on a certain right, and you're advising a defendant on the same issue on the other side. As an IP practitioner, how do you balance? Because on law, you can't fiddle much. You have to draw lines.
Yeah.
Thank you.
Yeah, thank you. And this is what our next topic leads to is conflict of interest. So we'll probably frame similar question in our like key issues. Vasundhra, you take care of it while handling conflict of interest situation while representing different clients. I can go ahead with the conflict of interest from in-house perspective. Yep. So I'll give you an in-house answer. What do you mean by conflict of interest for me? And probably Vasundhra can give a from practitioner perspective. For conflict of interest for an organization is a conflict of interest from different team organization. One team within my organization can give something back to an end customer which another team has not approved of it. And that's why managing the risk position. But probably I'll come to that later because this question is more from a practitioner perspective, and probably Vasundhra, you can take that and we can lead the conversation towards that.
All right, thank you. We were supposed to talk about conflict of interest, but that's perfect. We're talking about conflict of interest, and that definitely arises in our world. And I'm not talking about only intellectual property. I'm talking about the broader scenario. In every aspect, as a lawyer, you do have the conflict of interest that you face in sometimes when you're representing too many clients. For me, as a practitioner, I would say it's important for a complete transparency and disclosure. And I make sure that before taking up a matter, I do have the consent of the client in terms of the intellectual property that they're disclosing. Apart from that, it's very important to understand in some very complex intellectual property matters, till the time you're not infringing on a patent or a trademark or a copyright of the other organization that you will be representing, that's perfectly fine. That's a gray area that you have to, that you face on a regular basis. But in terms of conflict, if it's a direct conflict, then you usually avoid taking up that matter for a certain period of time till the time the conflict is remedied, or it's, you don't have the conflict any further. So transparency, extremely important as a lawyer to be transparent and not to withhold information from your client in terms of if there is a conflict of interest. Secondly, having a broader range or a full spectrum consent from your client helps you in taking it forward. Other than that, I certainly advise other lawyers or people or just general practitioners that in terms of conflict, till the time it's a live conflict, you definitely have to avoid that matter. But if it's something which is not going to be, you're not supposed to entail that during your litigation, then that's perfectly fine to take up that matter. So it's very subjective in that sense. I mean, you don't have
my
a clear
question was
cut.
more on legal issue, not on the same issue, conflict on both sides. But let's say on an issue defending a claimant in one set of things, on the same issue, the defendant
Then you definitely have
legally
that.
you're not bound by conflict of interest per se. But then how do you switch into different cases on different sides, and especially if you are now in India going before an IPD, which probably is only one judge or two judges. So he's seeing you standing on different cases, on different sides, on the same issue, taking different stands.
All right,
is there an
perfect.
ethical issue there or not?
There is a certainly ethical issue. All right, to answer it, I mean, that happens on a regular basis. You have senior counsels representing, Airtel, and then the same counsel is representing Vodafone. So you have conflict of interest on a regular basis, but till the time you're not hampering the first client, and the first client gives you consent to represent the other client, then that's a gray area that every practitioner has to follow. So there's no clear-cut answer to it, but I will say that's a gray area that has to be explored. But other than that, as a lawyer, I certainly avoid the conflict of interest happening and hampering the client that I've already represented.
Yeah,
Right.
and I'll try to summarize the discussion here. Probably from both of your discussions, three things are coming into play here. One is entity-wise conflict, of course, as Vasundhra given an example of Airtel and Vodafone. Another is subject matter conflict, probably a live subject matter conflict having the similar issue. And probably third and the most important is the consent. And before taking consent, it's your duty and responsibility to inform your client that these are the issues. And even after that, if a client is disclosing a consent, and you have to clearly clarify on two parts, if I have understood from the conversation here, like title as well as subject matter conflict, then probably it will be ethically correct to even you to ask the client, like, you want to give us a consent or not in these scenarios or not.
Can John share some American experience, how American law firms and ethics board handle? Is there an ethical issue here or not?
So, I mean, just anecdotally, what I hear from my friends that work in law firms in the U.S. is there's a clear wall between the prosecution side and the litigation side, and then also between the different clients that are being represented. And they take great strides to maintain those walls and those that confidentiality between the different parties. So I don't know, again, specifically what the law or prohibition would be, but I believe there's one in place that would prevent the same person, same attorney, from representing both sides of the coin in different matters. So, at the USPTO, though, we as employees are constantly conflicted out of certain matters. If we have spouses that work for a company, we're reviewing their application for patent or trademark on. So there are certain instances where we have to recuse ourselves because of conflict. But generally, you know, it happens few and far between, but it does happen.
Yeah. Thanks, John. I think it's more subjective and has to be considered on a case-to-case basis, what's happening, and better to not draw any line around it, because everything is organic, like too many information flowing around it, and it's good in an ideal way, the way it is as it is, in my personal experience, because it gives you necessary freedom to choose, and it gives the necessary freedom even for the clients to choose you or not. Yeah, so I think we have captured that particular, and I'll give you a more from an in-house perspective, like this is between customer and practitioner. There are conflict of interest for in-house as well. And as I mentioned, like we have different teams in our organization, one sitting in Israel, one sitting in US. So we have a conflict of interest there. One team is working on a product line which is completely competitive, which is completely should not be done because we have partnered for that solution with someone else. And we are not sure what team in Israel is doing. And we have created Chinese wall, like you mentioned, that we will not be doing it, but still we are doing it. And once it is come back to the product review board for us, then only it's the time when we are becoming aware that should not have been done. Now, energy is spent, resources have been spent, time of those individuals have been spent, and everything goes out, and we have to sit back and understand like whether it is allowed or not allowed. That's one form of conflict of interest while working for in-house attorneys. And there are conflict of interest within the legal department as well. And let me state very clearly, like for me working, for example, a lawyer working in my organization has given some form of representation somewhere outside India, US. Those representations might not have been approved by an IP attorney working in my organization. And once I'm sued, then everyone fall back, okay, in the IP department, why these representations of non-infringement, allowing of marketing capacities have been approved. And then at that point of time, we again have to manage the conflict of interest within the legal team as well. So I think it's two sides of the same coin within the organization. And when that organization comes back to practitioner, there's different definition of conflict of interest in that perspective. Yeah. Perfect. Thank you for that question. Probably we'll move to duty of disclosure, which is primarily US specific, and there's like very less parallels to be drawn. John, can you just give more highlights on like what are the four corners of law for duty of disclosure in US?
Sure. So when we think about disclosure, ultimately it boils down to what is in the oath and declaration that is signed by the applicant at the time of filing for a patent or a trademark. And within the patents section, there is this duty of candor and good faith before the USPTO, and duty to disclosure is part of that. But just taking a quick step back recently, because we've been taking such a close look, not just within the USPTO, but across every branch of the US government with respect to artificial intelligence, how to ensure safe and that we use AI responsibly and safe and secure. And at the same time, we want to be able to support the technological advancements of AI as it develops more global solutions. But it made us, there were a lot of questions that you might be aware of is that can AI be an inventor? Can they be an author? And all of these eligibility questions. So we came out just a couple weeks ago with some updated guidance. And really that guidance says that our existing laws handle AI just like they have handled every other emerging technology in the past 200 years, from the sewing machine to the automobile to the computer, and now to these advanced computing systems, AI, quantum computing. But we did one thing in this guidance. We clarified and basically we reminded applicants of their duty to disclose. And that's basically they have to disclose in their application or in the papers accompanying their specification all known information material to the patentability, and this extends to the inventorship and to the respective contributions of those inventors. So it's kind of going back to the AI aspect, but ultimately whether you're aware of some piece of prior art that you're not providing to the office, if ultimately you were granted a patent and ultimately it was discovered that you were aware at time of filing of this material information and did not supply it to the USPTO, it could impact the validity of your patent and it could be withdrawn. So this duty to disclose is a big part of it. But the other thing we did in this guidance, which was very interesting, is we also reminded applicants of their duty of responsible inquiry. And that's something that, in my career, we haven't spent, I went back and looked, and it's always been there, but it's not something we really focused on. We really focused on duty to disclosure because we want to look at, the information that the applicant knew at time of filing. But the duty of responsible inquiry is essentially to make sure that each party presenting a paper to the USPTO has a duty to perform an inquiry that it is reasonable under the circumstances. And this is primarily to ensure that any paper is not being presented for any improper purpose. And so again, kind of in the concept of AI, we don't want people making up names of or adding names of an AI engine as an inventor. And so we reminded what those inventorship criteria are, and then we tied it to the existing duties to disclose and the duty for a reasonable inquiry. So all of those are available on USPTO's website.
Okay, thanks, John. So primarily what's duty to disclose in US in summary is like everyone has to disclose everything regarding patentability before patent office, and it will overrule any kind of confidentiality obligation of that particular individual. We don't have similar provisions in India, but we have a couple of provisions, and probably Vasundhra can just highlight few of them, what's there in India vis-a-vis duty of disclosure.
Sure. Thanks, John. Thanks, Saurabh, for that question. All right. So we do have a duty of disclosure very much there in India, and that's being a common law jurisdiction. Most of the clauses are of specific intellectual property law. So I'm talking about patents, I'm talking about trademarks or copyright are similar in most of the jurisdictions. So US, EU, India, I think the common law, the big common law countries, and for that matter, even Japan for that matter. In India, we have the duty of disclosure definitely ingrained in our Indian patent law, where Section 8 specifically deals with disclosure. So prior to filing an application in India, if you filed an application somewhere else, by either be it the USPTO or you filed it with the EU, the European Union, the Benelux countries, you have to definitely have the obligation to provide all the disclosures. So as John mentioned, all the prior art, all the disclosure that you have relied upon when you filed that matter in the USPTO or the EU. You have the responsibility to give it across when you're filing the Indian patent. And for that matter, it's very important to understand that as a lawyer, we definitely have that responsibility to let the client know that all the disclosures are important. For them, it might be a very small disclosure. They might have relied on some specific invention that happened some 50 years ago, but still, I mean, if you have relied on that, you definitely have to disclose it. Prior art search is very important to follow, and that's a difficult thing to go about because a lot of times you overlook that, but that's something that you have to look at. And it's very interesting because when you go in for litigation in these particular scenarios, you have, it's still a gray area because the court comes up and says that if you're filing a specific claim which says that Section 8 is the part where, which has not been followed by the client. The court has a discretionary power in that sense because in Section 64 of the same law, which says that it's a power upon the court to take it forward or to not take it forward. So I think the case that, the landmark case that happened in India was specifically was Phillips. And it wasn't a willful non-disclosure, it was something that was inadvertently done. So the court definitely looks at the intention of the party. So if you're willfully not disclosing what you've relied upon, then that's definitely something that you'll be barred, so your patent will be revoked. But if you've not willfully done it, if you've inadvertently misplaced a particular disclosure, if you've not mentioned just because you were not having that document at that point of time, then it's on the court's discretion to take to consider it, a gray area and to revoke your patent or finally to cancel your patent in that sense.
Yeah, thanks, Vasundhra. And the key word here was, I think, willful non-disclosure, and it might kind of act as a estoppel against you, and it will grant the necessary right to the court to decide whether they should utilize as a estoppel against you based upon the facts and circumstances of that particular case and scenario. Yeah, definitely. In the interest of time, we were scheduled to discuss on unauthorized practice of law, neglect, dishonesty, which John has given a broad overview during the start, and probably we'll touch base very quickly on unauthorized practice of law, and probably it's very known to everyone that you should not be practicing if you are not a, say, registered patent agent. And we have necessary provisions for that within our own Indian Patents Act 129 to 132. And similarly, I think, John, you have mentioned that we have similar provisions in US and other jurisdictions as well, where this unauthorized practice of law is completely barred, and probably you can give some more examples on that part in this particular topic.
Sure, and I'll be brief, but basically I had mentioned this domicile rule in 2019 on trademarks, where you now, in order to file a trademark before the US, we actually adopted an international best practice that you also need to file that application through a US attorney. So what we found happening is several countries that had these large trademark filing firms and engines that were filing in the US previously reached out to some US counsel, many US counsel, asking if they could use their credentials, and they'll just pay them a nominal sum of money, use their credentials so that they can file the applications through them. And this is something that violates our rules of conduct at the USPTO, because in order to, when you put your name as a representative of the applicant, you are saying that you've reviewed the application, you've done the best interest of the applicant and as their client. And for someone just passing the work through, and so we've seen instances where hundreds or thousands of applications were funneling through different attorneys. And so we've posted, so there's been many, just in 2023, we had, I think, 115 of these various sanctions where we've either temporarily suspended licenses, or given the egregious nature of the issue, they may have lost their license completely or turned in their license. But a lot of times we've seen instances where the U.S. trademark attorney was the U.S. trademark attorney was identified as the point of counsel, but the actual foreign filing company was signing the inventors' names, was again, filing through this U.S. Counsel was creating a lot of issues for us. And we've also seen instances, primarily in India, we've seen one in Pakistan, we've seen a few in China. And one of the reasons we adopted this domicile rule was because of the tremendous influx of fraudulent filings we had been receiving from a lot of it was coming from China and from some other countries as well, where the trademarks were just manufactured. And so this is why we employed this domicile rule in the first place. And we're still seeing some of that behavior, but it has helped to mitigate some of those fraudulent filings. But we're seeing a lot of different types of trademark scams as well. We just saw one a couple weeks ago where they actually signed the trademark commissioner's name, used USPTO letterhead, and tried to assert that they needed to file these extra documents with these extra fees in order to maintain their registration. So we're seeing a lot of fraud before the office, and so a lot of it is because of this this domicile rule and people trying to circumvent it through through inappropriate means.
I'm just glad to know that. I'll just give a brief in-house perspective to it. What for unauthorized practice of law, in addition to your professional requirement to practice, we have seen a couple of paralegals working who is responding to USPTO calls and making necessary changes on the fly. So that one thing which we as an organization have strictly stated that whomsoever is receiving a call has to delegate to an authorized personnel to practice. So we face similar situation where one paralegal has agreed to make a couple of changes in trademark application, and of course that's one form of unauthorized practice of law from our perspective. So we have seen those cases in the past. So probably something from unauthorized practice of law from an in-house perspective, like what we are seeing on a day-to-day basis as well. Yeah, so probably in the interest of time, we have like few broader topics which we all are aware, and by way of definition is neglect, dishonesty, fraud, misrepresentation. So if anyone, Vasundhra, if you guys want to close that with any other topic, and John, probably you can, we can take questions after that.
All right, thank you, Saurabh. So we've talked about ethics, and we've talked about there are many scenarios where an attorney faces clients who've been accused of, many specific misrepresentations of fraud, for that matter. So as an attorney, you definitely have to be, you have to do your own due diligence before you take up these matters. Your due diligence as a lawyer, not only it's for the best, the best practice, but also for the sake of not taking up a matter which you regret taking up later on. So issues of misrepresentation happen very often in copyright infringement matters. A lot of times there are issues of plagiarism that come out at the later end of it. So that is something that you have to avoid as a lawyer. You have to make sure that the client is relying on something that he has to put forward or she has to put forward in the footnotes. And that's happened a lot of times. I think plagiarism has engulfed the area of copyright. And for that matter, patents has been engulfed by the issue of patent trolls. I think that's extremely important to take forward. I think patent trolls are something that you have to avoid as a lawyer. Other than that, as John was talking about, there's during filing of trademarks, or even during trademark infringement matters, I think it's very important to understand that trade dress has to also be, trade dress is also an important aspect. An infringement of a trademark just for the sake of going to court and putting it forward does not make sense till the time you have substantial evidence to prove that there has been some kind of infringement of your trademark. And lastly, I would say, issues with regard to corporate espionage. I think that's something that happens very often, and that has to be avoided as an intellectual property practitioner. Issues, and lastly, issues with regard to cyber squatting. I think those are the broad scenarios that I look at where a lot of fraud, a lot of misrepresentation happens on a regular manner. And as a lawyer, you definitely have to be very cautious about not taking those clients or those organizations forward in terms of whenever the litigation happens or even during the prosecution stage.
Yeah. Thanks, Vasundhra. John, any example?
I think in the interest of time.
Yeah, sure. So, yeah. So probably we'll close this session, and thank you for such a wonderful audience. And probably we'll close this one with one recent judgment from Delhi High Court where a practitioner has submitted a fraud order of an intellectual property board in a litigation before Delhi High Court, and division bench last year has issued a direction to the Bar Council to issue appropriate directions against the practitioner. So it's very important to keep us aware of these issues. Of course, there are n number of things to talk about it, but in the interest of time, we tried to give a flavor from a USPTO perspective, from a practitioner perspective, and what an ethical consideration can be considered from in-house perspective. So hope you all had a wonderful session, and we are open to take questions.
Actually, can I just add one?
Yes, please,
thing?
John.
I did want to share, we do have something in the US that in most of our states, not in all of them, but it's a requirement for continued legal education, a certain number of hours every year that have to be dedicated to your legal field of focus. And part of that is a requirement for at least 1 hour every year of ethics training. So I know India doesn't have a CLE requirement, but I do think it goes a long way in helping to raise the responsibility of the bar.
Absolutely correct, John. Yeah. Okay. Glad to have such a wonderful audience, and we are happy to take questions if you have any. Yes, please.
Yeah, warm wishes to all. I just have one question. After post-COVID era, we are living in a nation where research and development is not as much as par with the Western nations. So when it comes to the R&D and the patents being filed by the pharma companies, what about that? There has to be an ethical line being drawn, then that has to be in the beneficence of the people across the world, because when it comes to Asia, when it comes to Africa, such type of patents won't be there, and those patents must be shared by the Western countries. What's your take on that?
I'll just comment briefly that what it boils down to is access, right? It's not so much ethics, it's really access. And we've had some great examples of promoting that access throughout COVID globally. And at the same time, we have to make sure that while we support access, and there's so many great examples of patient assistance programs where drugs are donated, the U.S. government donating drugs as well, and other governments around the world into the developed countries, and also through voluntary licensing, the transfer of the technology and the know-how at no cost to many of Indian generic companies throughout COVID to help in boosting the supply of these medicines. So this was, again, I think it was out of responsibility in ensuring access to medicines, but at the same time, we have to be very careful that we don't tip the scale and upset the ability to secure protections for these innovations. Otherwise, we will lose the incentive to invent and lose the incentive to create the next solution that the world needs to solve our next big pandemic.
Thank you, John, and probably in the interest of time, we are around for any further questions if you have any. Thank you, everyone, and thank you, organizers, for such a wonderful session.